How does pain and suffering affect your car accident settlement? If you've been in a car accident, pain and suffering can play a huge role in the amount of compensation you receive. In this video, I'm going to explain how pain and suffering affects your settlement, why it matters, and most importantly, what steps you can take to make sure it's properly accounted for in your claim. Hi, I'm attorney David Bronze. I started my career working for the insurance companies, and that meant my job was figuring out how to pay people like you as little as possible. Seeing how that system worked from the inside is exactly why I'm sharing these videos. I want you to know the same tricks I used to use against people so that you can protect yourself. And if you ever need to talk to an attorney you can trust, call me at Bronze Law. We are always here and want to help. All right, let's get into it. Today, we're diving into pain and suffering, which is one of, if not the most important factors in your car accident claim. While many people and adjusters focus on medical bills and lost wages, pain and suffering can significantly increase the value of your settlement. I'm going to explain how it all works, how it's calculated, and most importantly, how you can ensure that your pain and suffering is taken seriously in your claim. First, let's talk about what we mean by pain and suffering. Pain and suffering refers to both the physical and emotional distress that you experience as a result of your accident and injuries. Physical, mental, emotional. It's the pain, discomfort, and the emotional toll that comes with not being able to do the things you could do before, like going to work, spending time with family, or enjoying activities you once loved. It's also the mental strain like stress, anxiety, depression, and the trauma that can follow a car accident. Now, here's why pain and suffering matters in your settlement. Unlike medical bills, which are straightforward to calculate and appear on a document with numbers, pain and suffering is considered a non-economic damage. What does that mean? It means it's not based on receipts or wages or hard numbers. It's based on the impact the injury has had on your life. And that's why it's often difficult for insurance companies to calculate fairly without sufficient documentation. The law allows for compensation for pain and suffering, and it can often be a significant part of your settlement. But the more proof you have, the better your chances of getting the full amount you deserve. This includes medical records, witness statements, and even personal documentation about how the injury has affected your day-to-day life. It's important to recognize that insurance companies often downplay it. Heck, I used to when I worked for them. They're going to focus on physical injuries, and they're going to argue that your emotional distress or pain isn't serious or not related. That's why the more organized and detailed your documentation is, the stronger your claim becomes. You want to keep a record of how the injury affected your life. You want to document if it's causing you sleepless nights, preventing you from working, or causing you to miss out on family events. These are things the insurance companies may try to ignore, but they're real impacts that deserve compensation. So now that you understand what pain and suffering means and why it matters, let's talk about how insurance companies typically calculate it. They often use two methods to determine how much compensation you should get for pain and suffering: the multiplier method and the per diem method. In the multiplier method, the insurance company takes your economic damages like medical bills and lost wages and multiplies that total by a number, usually somewhere between 1 and 5, depending on the severity of your pain and suffering. If you Google "what's my claim worth" or settlement calculators, you're going to see a lot of this. The old rule of thumb that you take your specials and multiply it by 3 to 5. But I will tell you that that's not the case anymore, especially with claim software and AI. The more serious your injuries and the longer they last, the higher the multiplier. So if your medical bills and lost wages total $10,000, they could apply, say, a multiple of 1.2. And that means you could be receiving a settlement offer of $12,000 for pain and suffering. Alternatively, the per diem method involves assigning a daily dollar amount for your pain and suffering. And this is what trial lawyers like to do at trial, by the way. This is based on how much you suffer each day after the accident. The insurance company then calculates the number of days you've been affected by your injuries and multiplies that number by a daily amount. Let's say they assign $100 a day for pain and suffering, and you've been suffering for 90 days. Well, that's an additional $9,000 to your settlement. Trial lawyers like to use a per diem argument and say, hey, even if we pay the person minimum wage, it's a job no one would want. So we take minimum wage, we multiply it by 24 hours a day, the number of days you were hurt, and that's going to give you a bigger number. That's a great trial lawyer technique that a lot of trial lawyers use to kind of anchor the pain and suffering to a real number and also relate it to something a jury can understand. Now, of course, these methods can vary, and there's really no set rule for how much you'll get for pain and suffering. Insurance companies, being insurance companies, they're going to try to give you the lowest number they can, but having detailed records of your emotional and physical pain can only help increase the amount you're compensated. So here's how you can make sure your pain and suffering is properly accounted for in your settlement. First, start keeping a detailed pain journal. Write down how you feel every day, how the pain affects your mood, your ability to work, and any other part of your life. The more detailed you are, the the stronger your case will be. Second, make sure you're seeking professional treatment for your pain. This might mean seeing a doctor, a therapist, or other medical professional. Their notes and reports will provide evidence of your pain and suffering. And here's a pro tip. When you are talking to your medical providers, I want you to think about your worst day or your worst moment since the last time you saw them, not your best. You want the records to reflect the worst of what you're going through, right? It's human nature for you to just be thinking about what you can do. You want to be positive. You want to be thinking about how you're getting better. So instead of saying, oh, today I could walk around the block, think about the 2 hours later when you were in bed and you couldn't walk because your back was all torn up from having to bend down and pick something up in the house. You're not lying. You're just choosing which filter you're looking at your life through. Third, I want you to collect witness statements. Damage witnesses is what we call them. If family members, friends, or colleagues can speak to how your injuries have affected you emotionally and physically, get them to write it down or talk to them and record the conversation with their permission. These personal accounts can make a huge difference in proving the impact your injuries had on your life, because now it's just not you saying it, it's third parties who know you telling an adjuster how you've been impacted. If you're dealing with pain and suffering after a car accident, give us a call at Braun's Law for a free consultation. We're going to make sure you're not shortchanged by the insurance company and get the compensation that you deserve. And if you want to learn more about what happens when the insurance company declines your claim, be sure to check out our next video. I'm going to walk you through what steps you can take to protect your rights and fight back against their tactics.